Well, good afternoon, everyone. I think people are still signing in, but we may as well get cracking. Welcome to the latest instalment of Brickcourt Chambers' Lockdown Homeschooling Talks. And today we're going to be looking at the role of the Competition and Markets Authority in enforcing consumer law. An area which, as you'll know, is bedeviled by complex and overlapping legislation at the UK and the EU level, and with a plethora of agencies and bodies administering and enforcing the rules, as a look at the CMA's guidance to the area will show. But we are focusing on the CMA today, and especially on litigation, which is what happens when the CMA and an enterprise under investigation can't agree on a solution to the identified problem. So our program for today is as follows. Firstly, Malcolm Birdling is going to give us a Joe Wicks style workout on the sort of cases that the CMA handles and the investigatory and the coercive powers that it has. And then Sarah Ford is going to give us an official briefing, strictly guided by the science, on the types of order that the CMA can seek from the court. And after that, I'll say a few words about possible future changes to the enforcement regime. So over to you, Malcolm, for the first presentation.
Well, thank you, James. I fear that comparisons with Joe Wicks are probably strictly limited to not being able to get to the hairdresser for 3 months, but we'll see what we can do. As James said, the subject of this seminar is litigating CMA consumer cases, enforcement, remedies, substance and reform. And I guess that makes me part of the resistance, as I usually act for those who have found themselves in the unfortunate position of facing enforcement and potentially remedies. So my brief for today is to give you the lay of the land. So to that end, I'm aiming to answer 2 basic questions. First, what is the CMA's role in enforcing consumer law and what type of case does it involve itself in? And second, what powers does it have? Does it have at its disposal? And how does it go about exercising them? And for those of you who like to skip ahead to the end of the novel, the short answer to the second question is the CMA has a lot of very powerful tools for investigating and securing compliance with consumer law, and it isn't shy about using them. And that won't come as a surprise to any of you who have advised anyone who's found themselves at the sharp end of the process. The CMA's main tool and the focus of this talk will be on its civil powers under Part 8 of the Enterprise Act 2002 to investigate and put an end to infringements of specified consumer laws. If traders don't play ball, the CMA may ultimately seek an enforcement order from a civil court, and you'll hear more about that process from Sarah later. While I don't have time today to address these, it's also worth bearing in mind that the CMA has a separate power under Schedule 3 to the Consumer Rights Act to seek an injunction to stop businesses using unfair terms or notices. And it also has a power to bring criminal prosecutions against traders that engage in unfair commercial practices, but we won't have time to deal with those today. Now, the first thing to note, as James touched on, is that most of the CMA's consumer law powers are actually shared with other consumer law enforcers, to use the language of the Enterprise Act. And in particular, local trading standards bodies, which are the lead enforcers of the consumer protection from unfair trading regulations. Indeed, trading standards have a positive duty to enforce them, whereas the CMA, on the other hand, has a power to enforce them rather than a duty. But it may take the lead in particular sort of cases. So that begs the question, what might lead the CMA to get involved? One possibility is the CMA receives what's known as a super complaint from a designated consumer body, such as Citizens Advice. A super complaint is defined as a complaint submitted by a consumer body that any feature or combination of features of a market in the United Kingdom for goods or services is or appears to be significantly harming the interests of consumers. So it's pretty broad in terms of what potentially could form the basis of a super complaint. Within 90 days of receiving one, the CMA is under an obligation to say publicly how it proposes to deal with it. And to give you an example of how this can be significant in prompting the CMA to take action, in September 2018, Citizens Advice submitted a super complaint about what it called the loyalty penalty in 5 markets: mobile, broadband, household insurance, cash savings, and mortgages. In the course of responding to that, as it was bound to do, the CMA actually thought there were rather more areas where this was a problem, and identified a bunch of other practices that they thought it would take a look at. In the end, what that led the CMA to do was to launch enforcement action in 2 sectors. One was antivirus software and subscriptions for that, and the other is an online console video gaming. So super complaints actually are a relatively significant potential source of work for the CMA. Another possibility is that the CMA, because it does various other things, not least regulating competitive markets in the United Kingdom, is that when it's exercising one of its other functions, it'll find something wrong. And a recent example of that is in respect of care home providers. In late 2016, the CMA commenced a market study in the care home sector with the objective of examining whether the market was working as it should. And in the course of that market study, the CMA identified some practices which it considered were inconsistent with consumer law. That wasn't the remit of the original study, but nonetheless, they found stuff that was of concern to them. So what happened was the CMA opened a separate consumer law investigation focusing on whether the charging models were lawful. And at the same time, the CMA consulted on what's called draft advice, setting out its views about what is and is not permissible in this particular sector. And it's worth pausing here to say a word or two about that advice, because it's helpful insofar as it contains the CMA's considered views on a particular topic, because you can go to it and you can see what the CMA thinks about something. And if you're advising a business, it's just a helpful tool to let them know what they can do to keep on the CMA's good side. However, they don't have any legal force, as the CMA actually makes clear on its face. They often deal with areas of the law where there is a considerable amount of uncertainty, normally due to a lack of direct authority. And what this means for advisors is that you ought to always approach them critically, rather than accepting them as an authoritative statement of the law, because they certainly are not the last word. Anyway, coming back to the sort of cases where the CMA may take an interest, the CMA has published guidance that says that it might decide to take action itself, that is outside of those areas where it's sort of come across something, in 5 scenarios. One is where there are breaches of the law that point to a systemic failure in a market. The second is where changing the behaviour of one business would set a precedent or have other market-wide implications, for example, making an example out of you, where there is an opportunity to set an important legal precedent, where there is a strong need for deterrence or to secure compensation for consumers or to uphold the effectiveness of the unfair contracts regime. So they're pretty broad, but hopefully for the purposes of this talk, although perhaps unhelpful if you're one of the companies in question, the CMA regularly publishes details of the cases that it's investigating on its website. So when I had a look through that this morning for preparation for this talk, there were 3 things that struck me. First, the CMA is actually highly active in using these powers. Second, it does so across a wide variety of sectors. And third, the targets are usually large online operators or operators in an industry that sort of spans wide geographical areas. So it's not your local road traders that trading standards would deal with. You're really dealing with people that are big hitters. And to give you some examples so you can see how that plays out in practice, it's investigated gambling firms in relation to gambling promotions and difficulties in withdrawing money from online gambling platforms, concerns about the fairness, clarity and presentation of leasehold contract terms, It's investigated secondary ticketing sites, social media endorsements, including action against what I think are termed influencers, online hotel bookings, fake and misleading online reviews, and in one case where Apple was providing customers with what the CMA deemed to be insufficient information about the battery life of their phones. So it's a pretty broad range of conduct and a pretty broad range of sectors, but the commonality is they're all pretty big operators that they're concerned with. So those are the sort of cases that the CMA normally concerns itself with. So turning to the second of my questions, as I mentioned in my spoiler at the outset, once the CMA has decided to investigate, it has a number of really quite powerful tools at its disposal. The first is that it can send a written notice to any person or business requiring them to provide information. And it's empowered to use that whenever it's considering whether to exercise one of its powers under Part 8 of the Act. So it's a very broad power indeed, and subject really only to legal professional privilege. The CMA is empowered to specify the time within which the information is to be provided and even the form in which it's to be given. And it can also require the recipient to create a new document containing relevant information. So again, a very broad power. The information that you provide when you're required to can be used in civil proceedings, although not in criminal proceedings. And the power is not limited to the subject of the investigation, so information can be requested from third parties as well. The CMA also has express powers to visit public parts of businesses to observe how the business is being carried on and to conduct test purchases, and it can do that without a warrant and without notice. And if those powers are insufficient, it also has very broad powers of entry and seizure onto premises, which also don't require a warrant unless the premises is a dwelling house or it's necessary to use force to gain access, where the assistance of the police, for example, might be required. And when they're on the premises, the CMA can search the premises, they can require those who are there to provide assistance, can break open containers, it can access electronic devices, it can inspect products, it can require traders to provide and give explanations of documents, and it can seize documents and goods that it's found. So again, a very broad set of powers indeed. CMA investigations, for those of you who haven't dealt with them before, can be very long, sometimes taking years, and involve repeated exercise of various of these powers and various permutations over a period of time. So that's the sort of main tools that it has domestically. But you will have seen from the list of organisations that are subject to the CMA's investigations, or have been, that they're quite often ones that operate online and across borders. So another important tool the CMA has at its disposal are access to information cooperation networks. This is worthy probably of a seminar in and of itself, not least because of the new Consumer Protection Cooperation Regulation, which came into force earlier this year and implemented domestically by regulations which came into force at the start of the month. For those of you who haven't familiarised yourself with this, you ought to, because it really beefs up the power of what's known as the Consumer Protection Cooperation Network, also known as the CPC network. To date, this has really been a sort of mutual assistance procedure whereby regulators in the EU member states and the EEA member states cooperate by collating information and evidence. But it hasn't had any tools to compel a particular domestic regulator to take any particular enforcement action. That's now changed. So the mutual enforcement and the mutual assistance framework remains. But member states are now empowered to require other member states to take enforcement action where harm has been caused in that member state. So requesting member state has some consumers that have suffered harm at the hands of someone operating in another member state, or even when the offending trader has assets or evidence there. So that's new, and that's not all. Because the new regulation gives both the EU Commission and the member states the powers to require other member states to take coordinated investigation and enforcement action at the national level where a reasonable suspicion threshold has been passed. So not a particularly onerous barrier to jump. In terms of how those changes have been implemented domestically, the UK implementing regulations effectively piggyback off the existing machinery with some tweaks. But there's one quite significant development, which is worth mentioning, which is that the CMA is now empowered to seek what's called an online interface order. Now, an online interface is defined as any software, including a website or part of a website or an app, that is operated on behalf of a trader, which serves to give consumers access to a trader's goods and services. So you see the broad swathe of e-commerce will be subject to these provisions. And what they allow the CMA to go to court and seek to persuade the court to grant is an order, either a final order or an interim order, requiring removal or modification of content from such an interface, disabling or restriction of access to that interface, display of a warning on the interface, or even deletion of a domain name and facilitation of the registration of that domain by the CMA. Now, to some extent, this is not entirely novel territory in this jurisdiction, because certain of those things have been sought and obtained by the CMA under the guise of enhanced consumer measures that I'll come on to in a minute. But this is now going to be available more broadly and also in other jurisdictions. So it's quite an important thing to watch. Should say that it's subject to a test of not quite proportionality, but the test that the court has to apply in order to, when considering whether to grant it, is whether there are no other wholly effective available means to prevent the infringement, and it must be necessary to make the order to avoid the risk of serious harm to the collective interests of consumers. So I guess there is an interesting question of whether that is a lower or a higher threshold than the court has to consider when looking at enhanced consumer measures. And Sarah's going to come on to talk about the test for that shortly. There's also some other changes coming down the pipeline, particularly in the context of fines, but I'll leave those for James to discuss. So the end game, at the end of the investigative process, the CMA will either form the view that the trader is blameless or that some further action is needed. And assuming that they haven't decided that the trader is blameless, they'll move to what's called a consultation phase. Sarah's going to deal with this in more detail, but the essential purpose is to give the trader a final opportunity either to persuade the CMA that its concerns are unfounded, brackets good luck, or to put things right. What the CMA invariably seek from traders are what are called undertakings, that is voluntary commitments from traders promising not to repeat the conduct, and in some cases further make measures to make good consumers who've suffered harm. The CMA isn't bound to offer undertakings, even if they're offered. It can decide to push on and say, no, only a court order is really good enough. And its published guidance is that it won't accept undertakings where it considers they're unsatisfactory, where they think they're unlikely to be honoured, or where for some other reason it's seen as essential to bring a case before the court. The reason why the not being honoured bit is there is because breach of an undertaking is not itself punishable as contempt of court. So they're not undertakings to the court. What it is liable to do is prompt further enforcement action. So if a trader doesn't comply, or the CMA considers the trader doesn't comply, it's likely to prompt some further action, which could include an application for court. And one of the factors a court is obliged to take into account when considering an application for an enforcement order is whether there's been non-compliance with previous undertakings. For completeness, I should say that if you're ever in the situation where the CMA is concerned that an undertaking might not be honoured, an alternative that is open is to seek to agree a consent order with the CMA that will then effectively be endorsed by the court as a curial order. Meaning that while the claim will have to be issued and a judge will have to approve it, you don't have to go through the whole process of a hearing, and that will mean that the order itself will be punishable as a contempt of court without having to take separate enforcement action. So there is a mechanism by which this can be done without effectively by consent, but with the court casting its eye over it. The final thing I want to touch on before I turn over to Sarah is enhanced consumer measures, which I sort of briefly touched on earlier. These are relatively new tool. The Consumer Rights Act in 2015 introduced them, and they are measures that the CMA can seek when it seeks undertakings from a trader, or it can seek to persuade a court to grant when it seeks an enforcement order. They fall into a range of categories, which I'm not going to go into any detail about now, because the one thing I really want to emphasize with these is that they give a large amount of discretion and flexibility to the CMA in what they consider is necessary or proportionate or just in terms of putting consumers right and stopping conduct it doesn't agree with happening again. And that's not accidental, because if you read the explanatory note to the Consumer Rights Act, it said the provisions were formed deliberately, broadly, because the drafters didn't want to risk taking away flexibility from the courts and enforcers of consumer law to identify the most suitable measure or measures for dealing with the person subject to enforcement orders or undertakings. So very broad scope of what potentially could go into an enforcement order seeking enhanced consumer measures. And for those who haven't seen one before, they can be very prescriptive documents. So the consent order that was agreed between the CMA and Viagogo, for example, ran to 31 pages. And you can scroll through on the CMA's website the terms of the undertakings and orders that have been agreed or imposed before. And you'll see the things they can include can be things like prescriptive requirements for the operation of consumer websites, down to sort of minutiae like the text that has to be used on particular pages and where that text has to appear. And there's some obvious overlap here with the new online interface orders, which I touched on earlier. So it'll be interesting to see how the ECM jurisdiction and the online interface order jurisdiction interplay. They can require the establishment of a redress scheme overseen by an independent monitoring trustee, which the trader has to pay for, with wide powers of access to records, with a view to refunding consumers who may have suffered loss. Introduction of internal compliance policies, introduction of training, monitoring, auditing, and also compliance with periodic monitoring regimes run by someone independent, again at the trader's expense. So the upshot is there can be quite a lot at stake when the CMA come calling, and the CMA have quite a lot of powers at their disposal. So I think that's all the time I have, so I'll pass over to Sarah and James now, but thank you for your time.
Well, thanks very much, Malcolm. And we'll go more or less straight over to Sarah, just to say, I think with your joining instructions, you were told how, if you should wish, you can ask us any questions, which we'll deal with if we can, if they're polite, and if time allows, at the end of the seminar. You can send an email to itsupport@brookcourt.co.uk, or I think also to marketing, but don't expect any of us to be looking at our email, so we'll pick those up later. And with that, I'll hand over to you, Sarah.
Good afternoon, everyone. The focus of my talk is what happens if a person is accused of having infringed consumer law, but they either dispute the CMA's assessment or they dispute its proposed remedies. And what happens then is that the CMA will make an application for an enforcement order under Part 8 of the Enterprise Act 2002. The Enterprise Act designates the CMA as a general enforcer, which means that it's empowered to make an application for an enforcement order in respect of any infringement. There are two types of infringement. There are either domestic infringements or community infringements. And in very broad terms, as you might expect, a domestic infringement involves a breach of a UK statute, UK consumer protection legislation, whereas community infringements concern a breach of either a directive or a regulation, so EU law. If the CMA decides it wants to make an application for an enforcement order, it first has to engage in what the Enterprise Act describes as an appropriate consultation with the person who's going to be the target of the order. And to a certain extent, this period of consultation isn't necessarily a further opportunity to persuade the CMA that there's been no infringement at all, because the wording of the statute actually assumes the existence of an infringement. And what it says is that the appropriate consultation is intended to achieve the cessation of that infringement, or to ensure it doesn't happen again, or to ensure a threatened infringement doesn't happen at all. And so the function of this provision is really to ensure that the courts aren't troubled with these matters if it's possible to ensure appropriate compliance or enforcement by other means without actually having to then have recourse to litigation. The process of appropriate consultation also doesn't take the place of a pre-action letter. So in addition to the process of consultation, you would also expect to receive from the CMA a pre-action protocol letter, and the usual penalties and costs would apply unless there are good reasons if that didn't happen. So what this means is that by the time proceedings are commenced, you would normally have a pretty good idea already of what the CMA's concerns are, because you would have been involved in a process of investigation with the CMA, you would have been involved in a process of appropriate consultation, and you would also have received a letter before action. In terms of jurisdiction to grant a enforcement order, either the High Court or the County Court have jurisdiction to make an enforcement order under the Enterprise Act. And there is one condition for the exercise of that jurisdiction, and that is that the person against whom the order is sought must either carry on business within England and Wales or must have a place of business in England and Wales. Assuming that the court has jurisdiction on that basis, the next question is, should the proceedings properly be started under Part 7 of the CPR or under Part 8 of the CPR? Part 7 is the usual procedure that's used in litigation for contested claims. Part 8 of the CPR is a special procedure, and it's described in the CPR as being suitable for claims which are unlikely to involve a substantial dispute of fact. So classic examples leaving aside consumer law would be a claim which turns on the construction of a contract, or potentially a claim which relates to statutory construction. So largely matters which can be resolved by means of legal submission as opposed to factual disputes. And if you think about the run-up to consumer enforcement proceedings, in many cases, a consumer protection claim might well be suited to Part 8 proceedings. You have, as we've discussed, a fairly extensive process of information exchange and evidence gathering by the CMA in advance. And it may be that at the end of that process, there is a degree of common ground about what exactly is the conduct that has taken place and what is the conduct that's the subject of concern. And then the question between the parties will be, well, how do you characterise that conduct? Does it satisfy the statutory test for an infringement or not? And that will be a question of statutory construction and legal argument rather than for factual evidence. And if that's the case, it might well be in a party's interest for the proceedings to proceed under Part 8, because Part 8 is intended to provide a process which is relatively proportionate, both in terms of the time it takes to resolve the dispute and the expense of resolving the dispute. And an example of that sort of situation is the purely creative case, where the OFT sought an enforcement order in respect of unfair commercial practices under the Consumer Protection from Unfair Trading regulations. And the judge in that case recorded in his judgment that there were no significant issues of primary fact. And he explained that the reason for that was that because the OFT had exercised its statutory powers, it had sought and the defendants had provided substantial and detailed information about the conduct that was the subject of the proceedings. And so in relation to questions such as whether the conduct would be likely to mislead the average consumer, the judge explained in his judgment that the parties had wisely abstained from trying to address that question by reference to either expert evidence or statistical surveys or evidence of that nature. And he put down his view on the face of the judgment that by not taking that route and by declining to cross-examine witnesses, he said the parties are to be commended for having thereby avoided what would have otherwise been the near certainty of giving rise to a trial of disproportionate length and expense. And he was satisfied that the various issues that arose on that case were essentially issues as to the application of the regulations to uncontentious facts and potentially what inferences should be drawn from the uncontentious facts. And it was clear that in his view, this was the sort of dispute that was very much suitable for a Part 8 proceedings. So depending on the particular circumstances of the case, a party might well consider it's in their interests for the matter to proceed under Part 8 and to be determined quickly and at proportionate cost. In other circumstances, it may be that a party wishes to contest whether the proceedings are appropriate for Part 8, and then there is a mechanism under the CPR whereby they can make an application and challenge the commencement of proceedings under Part 8 and request that the proceedings continue under Part 7. That's what happened in the Care UK case. There was an initial application which was determined by a deputy master, and then there was an appeal under that to a deputy judge. And there were 2 points in issue on the appeal. The first was that the deputy master who had heard the application had noted certain terms in the pleaded case, and he noted that the allegations were that conduct would deceive or was likely to deceive the average consumer, and that certain bodies corporate had consented or connived in the conduct of other members of the corporate group. Now, that is statutory language that appears on the face of the relevant statutory provisions, but the deputy master was concerned that those sorts of allegations might amount in essence to an allegation of fraud. And he said under the pre-CPR procedure, it was very clearly established that an allegation of fraud and of dishonesty was not appropriate for a Part 8 procedure. On appeal, it was held that the deputy master was wrong in that respect. The statutory language is essentially EU-derived consumer protection legislation, and it doesn't equate to an allegation of fraud or dishonesty. But the second point on the appeal was whether, nevertheless, there was a substantial dispute of fact between the parties which made the claim unsuitable for a Part 8 procedure. And that's a question which is decided on the basis of the pleadings of any particular case. And on appeal, it was held that there were factual disputes which could be identified on the face of the proceedings between the parties. And so the matter was then directed to continue under Part 7. Once they're commenced, applications for enforcement orders proceed largely as any other claim. While it may make a degree of difference whether or not it proceeds under Part 7 or Part 8, actually it might not make as much difference as you might think. And the reason for that is that even under Part 8, the court has its usual case management discretion to manage the case appropriately and proportionately. And in particular, it can direct disclosure if it thinks is appropriate, and it can direct cross-examination of witnesses if it feels it's appropriate to do so. So in practice, whether the proceedings are commenced under Part 7 or Part 8, what you would expect is in the usual way, the court will case manage the proceedings according to the circumstances of that particular case. The end goal of the proceedings is to obtain an enforcement order, and the court may grant an enforcement order if it finds that the person in question has committed an infringement. And the enforcement order is a little bit like a final injunction. What it does is it first of all identifies the conduct which has been found to constitute the infringement, and then it gives a direction that the party concerned mustn't engage in that conduct, it mustn't continue the conduct, it mustn't repeat the conduct, and it mustn't consent or connive in that conduct by a related body. The enforcement order can be sought against what are termed accessories under the Enterprise Act. So if the person who actually engaged in the conduct which is the subject of concern is a body corporate, then an order can also be sought against a person who has a special relationship with that body corporate if they consented or connived in their conduct. And a special relationship means in that context someone who's a controller of a body corporate, or a director, a manager, a secretary, or another officer of that nature. The enforcement order can also be sought against other members of the corporate group without establishing the consenting and conniving prerequisites on the basis that they're members of the same corporate group. In addition to simply telling you not to continue to engage in the relevant conduct, as Malcolm has indicated, the enforcement order can also require you to take enhanced consumer measures. And those measures might be to facilitate redress for consumers who have suffered loss as a consequence of the conduct concerned. They might be to prevent or reduce the risk of non-compliance with the enforcement order, so focusing on ensuring ongoing compliance. And equally, they might be intended to enable consumers to choose more effectively between persons supplying or seeking to supply goods or services. So there are various goals that enhanced consumer measures can pursue. And the test that the court applies, or is obliged to apply under the enterprise, is whether it is just and reasonable for the enhanced consumer measures to be required, and also whether it's proportionate for those measures to be directed. And as you can anticipate, whether it is just and reasonable and proportionate will very much depend on the particular circumstances of the individual case. And so the court is going to have a degree of discretion depending on the circumstances that are before it, having heard the entire case, heard the trial, made findings as appropriate. So that, in a nutshell, is the procedural course of litigation.
Thank you very much, Sarah. Thanks very much indeed. As I think is very clear from both presentations, the CMA has a breadth of measures, weapons at its disposal, and a large number of forms of order that it can seek from the court. And as you've heard, particularly from Malcolm, often, of course, commitments, undertakings, or less formal arrangements can be reached by way of settlement or avoidance of proceedings. And the CMA can justifiably claim many successes in this area and has not hesitated to do so and issue press releases taking credit for significant advances on behalf of consumers. So the question arises whether the powers that it has, that have been so well described by my colleagues in their various nutshells, are those powers sufficient? Among those who think they're certainly not are the outgoing chairman of the CMA, Lord Tyree, who announced last week that he would be stepping down early, only 2 years into his post, and he'll be stepping down in September of this year. In February 2019, he sent a long letter to the Secretary of State for Business detailing proposals for substantially overhauling the legislative and institutional framework for competition and consumer functions of the CMA. In that letter, he said the central challenge is that, despite relatively recent legislative changes, the UK has an analogue system of competition and consumer law in a digital age. Strong words and a nice image. And he is, in the course of it, critical of the way the Competition Appeal Tribunal operates and the ability of lawyers to tangle the CMA up in arcane legal arguments for years, frustrating its mission. Specifically in respect of consumer enforcement, he essentially argues that the CMA should have equivalent powers to those that it has in the area of competition enforcement, modified as he would see it, as those should be in accordance with his prescriptions. So that in the consumer area, as in the competition area, the CMA should itself be able to make a decision that consumer protection law has in some way been breached, direct companies to bring those breaches to an end, and impose substantial fines on companies, a la competition enforcement, so turnover based and chunky. Those would be accompanied by enhanced ability to secure interim measures, interim enforcement, and the investigative process should be improved by compulsory information notices. So questionnaires around the industry would have to be answered and answered accurately, subject to penalties if not, and that directors could be disqualified for breaches of consumer law in the same way that they can for breaches of competition law. Now, those proposals were met generally with sort of warm words from the department, and there was a lot of support in the reaction of the department for what he had to say, particularly on the consumer enforcement side. And indeed, as he says in the letter, the government had already committed itself to, or at least saying that it was in favour of extending the competition fines regime to consumer protection, to the consumer protection sphere. And in communications about the proposals, as I say, the department has broadly been supportive and would propose to extend aspects of this regime to the concurrent regulators so that they would be able to enforce and apply consumer protection law according to their lights in the same way that they can in respect of competition law. The problem is that there is no sign of these measures coming forward. They seem to have been lost in the Brexit or COVID fog, and there is just no detail on what might be in the government's next set of proposals, or as far as I'm aware, when those actually might come out. I think all one can say is that one day there is likely to be change, and it is likely to be in the form of alignment on the competition enforcement regime that we all know and love. Now, this is clearly not fast enough for Lord Tyree, one entirely understands, and he said in his letter announcing his early departure that he wanted to be able to advocate for the changes that he sees as necessary more powerfully than he can do in his official role as chairman of the CMA. So he wants to take a more independent and less institutionally hidebound position in support of the agency and in support of the measures that he considers necessary. And one senses the frustration kind of rises off the page as you or the screen as you read his letter. I think it'll be interesting to see, and I'm in a sense responding to one of the questions that we've had before the seminar started. It will be interesting to see what he says when he thinks he can say it, which I assume will be in September after he actually leaves the CMA. In one significant development, the fining powers will arrive, ironically, due to EU legislation, as Malcolm was explaining about the CPC regime turning from a sort of mutual enforcement club to an actually mutual assistance club to one of actually enforcing, and more like NATO. You know, we call on you to react to this, and accompanying that by a deadline in the directive of, I think, May 22. the designated agencies of member states must have the power to impose what are known as GDPR style fines of up to 4% of turnover in the relevant member states, with a maximum fine which must be at least €2 million. If you see what I mean, they want to avoid member states having a regime which is just a slap on the wrist. So the fines, again, are meant to be chunky. I leave to their lawyers and accountants comment on the ability of some of the targets of these measures to achieve their turnover otherwise than in the member state where the consumer practice might be felt. In relation to the Tyree proposals, which, as I say, in some form or other are likely to come forward at some time or other, and just in the interest of being controversial and getting a discussion going, if not today in this slightly limited forum, then more generally, I certainly welcome the comments of my colleagues on the panel today. I'd like to suggest that actually these proposals should be flipped on their head, and that actually there is nothing particularly wrong with having to go to court to secure these outcomes. The proceedings can be done with dispatch and security, and interim relief can be, interim orders can be secured where they're justified. I actually think that this regime and a similar one for directors' disqualification works rather well, and should in fact be the model for competition enforcement as well. The protracted administrative proceedings that we see in the competition enforcement space, with multiple changes of case and directions and supplementary statements of objection, leads to extremely lengthy proceedings, and in my respectful submission, with the boot being on the wrong foot when it comes to the appeal stage. The appellant is already, in my view, on the back foot when defending against a decision, and it should actually be the other way round. It would be much better if the CMA put its case together and applied to court with the companies under investigation, then able to put in their two penneth and respond to a definitive statement of position by the authority under the control of a judge who these days are becoming much more familiar with this sort of subject matter. Indeed, I think, although I'm less sure about this, I'd be in favour of extending that regime to mergers as it is in the US. I mean, one thinks of the C.K. Hutchinson case in the General Court just the other week, hailed as a great victory for theory, which no doubt it is. But one asks, where is the fairness, or indeed the utility of such a victory 4 years after the merger was blocked? And returning specifically to the consumer powers, which is, as I say, I actually see as working quite well, I do suggest that before putting an end to this regime, we should actually see and have some experience of litigating some of these cases to, as it were, the bitter end, where undertakings, commitments and so forth cannot be secured. We should actually see how they go in court before concluding that this system is broken. Now, I don't know whether Sarah or Malcolm wish to express any views on that, and I would certainly welcome it. But that is what I wanted to say on those the Tyree proposals, if I can use that shorthand.
I agree with that, James. I can state my agreement pretty shortly. I think the scope of the remedies are very far-reaching. and are of the nature that really ought to be subject to judicial supervision. And practically, it's particularly important where the law is in many respects just entirely undeveloped. On the other side of the coin, where there is the prospect of immediate or imminent or ongoing consumer harm, what the courts have demonstrated is they can move really rather quickly indeed. The Viagogo case that I was involved in, the CMA served proceedings in late August. It managed to get an urgentification appointment for permission to serve out, or maybe it was on the first day after the vacation in September. And then it was listed for a 4-day hearing of the interim relief application just a matter of months later. So it all moved very quickly. And that's the sort of thing the courts can do when there's urgency. And I think that's the way these things ought to be managed, rather than removing ex ante judicial supervision, which I think would be potentially quite dangerous.
Thanks very much, Malcolm. And I do understand that Sarah, who frequently represents the CMA in this case, is probably going to keep her counsel and see everyone in court on this one. I have been sent a question, which I think is for Sarah, which is in relation to enforcement orders being directed against members of the corporate group to which the defendant belongs. And the question asked is, what factors might the court take into account when imposing an order extending liability in that way, and whether whether the provisions on connivance and so forth would need to play or can be sidestepped in this sort of formal order. Sarah, I don't know if you have views on that.
Yes, I think the Enterprise Act contains two slightly separate provisions. One enables the court to focus on related persons who have also been involved in the conduct in question. So, and it's not necessarily only another member of a corporate group. As I mentioned, it could be, for example, a director or an officer of the relevant corporate entity that's conduct is in question. And the focus of that provision is insofar as you've consented or connived in the conduct, and the meaning of consented or connived is essentially whether you knowingly either unknowingly participated or essentially passively allowed it to go on. The focus there is you had some involvement in the conduct, and so the court can then direct an enforcement order at you by reason of your conduct. The other provision is essentially an order which is simply directed at other members of the corporate group, and the logic of that is that what you don't want is a situation where an entity is engaging in conduct through one member of a group and can evade the efficacy of an enforcement order by simply transferring that conduct to another member of the group. So I think the two provisions have different aims and intentions behind them in statutory terms.
Thanks very much, Sarah. Thank you. We're approaching the end of our time, and I wondered whether either of you wanted anything further you wanted to add, given the relative speed with which we had to go through the presentations that you've prepared, or further war stories from the conduct of these cases, either at the administrative stage or in as litigation approaches. I think people would be interested in hearing a couple of other sort of live examples of how these cases go. And if we're not getting much purchase on that, and I suspect the note takers within our audience are probably getting a little tired anyway. I mean, I should just add in relation to what I said, that a lot of what's in Lord Tyrie's letter is, as I said, highly critical of the way the Competition Appeal Tribunal handles its procedures. And he says they've departed from their original mission, which was, to provide speedy justice and not get bogged down in extremely lengthy trials. And whether or not you think they've got bogged down, they certainly have rather lengthy trials. I think increasingly a sort of hybrid nature where parties can be criticised for not leading original evidence, despite what it says in the rules. But it's important to realise, if you try and keep a focus on this, that any validity those criticisms may have do not apply in this area of consumer protection, where the applications are to the ordinary courts, and they're not going to be interested in extremely lengthy trials. Sarah's quotation earlier from the purely creative cases was quite interesting in that regard. These cases are not seen as enormous battlegrounds between mastodons. They are procedures to be handled pretty briskly, and I think the courts are well up to that challenge. So I repeat my thought that in this area it actually works rather well, and it's not a broken system, whatever you might think in other areas. And I put my views on record on those as well, but that is a separate issue. Well, thank you everyone for turning up or tuning in on such a beautiful day. I hope there's some use to you in what we've had to say. Further questions after the event are certainly acceptable, but thanks very much, and there will be more from, say, Brickport lockdown homeschooling in due course at a computer screen very close to you. And so with that, I'll close the session. Thanks very much, everyone.